What? Why are you recording? Hi,
Hi,
Heather.
great to see you again.
Good to see you again. You can have a seat right there if you'd like. Do you need to use the bathroom or grab some water or anything before we get started?
I'm all good.
Okay. Well, I'm glad that you were able to come in again. I'm sorry. It sounds like the circumstances for your coming back are worse than they were before. Before we get into everything, I know we kind of touched on this the last time that we met, but I do need to go over and the our engagement and contingency fee agreement with you, just because we're kind of at a point now where we're past that initial interview intake stage. And since we're going to be talking and getting into like real legal advice, we've got to kind of have something in writing and have something signed. So I don't know if you had a chance to review it, but I'll go through it with you.
Okay.
Pretty much, it's just acknowledging that we are entering into this agreement, this contract for legal representation regarding your claim or claims against your employer. It discusses the scope of representation. So, we're talking employment related claims, and it kind of lists different things, and including overtime and retaliation, which sounds like we'll be talking about. It also specifies that our representation here doesn't include any appeals, which would be like after if we were to say like go to trial and got a decision that we didn't like. If you wanted to then appeal that decision, we would need to go and basically do another sign a different contract. It outlines my responsibilities, so I'm going to provide you with competent and professional legal services. That's the goal.
Yeah, I hope so.
Exactly. That's why you come to us. You're hoping that we actually are going to do the right thing. So yeah, I will make sure to do whatever I can to make sure that your best interests are represented, and keep you informed of anything that happens, developments, if I need anything from you or vice versa. And I won't make any significant decisions without consulting you first, especially if there's any discussion of like settlement or anything like that we will discuss. I will never make a decision without talking to you about that. And then the next part is your responsibilities, which are pretty much just working with me and being cooperative.
Well, the good news is I have a lot more time now.
Oh, well, is that good? Yeah, I guess, yeah, that is a good thing. Hopefully though, this doesn't take up too much of your free time. But yeah, so just going through, or making sure that we're working together, but also, and I think I touched on this last time, like if we need documentation, which with employment law claims, it's a lot of, I'm gonna need records and documents and things like that. So just making sure that you're getting those to me in a timely manner so that we're able to file what we need. And then it also just kind of discusses like not doing anything that could potentially harm your case, like speaking to opposing counsel, posting something about your claim on social media, like at least talk about that with me first before doing anything like that.
Okay.
And then the next piece is about the actual contingency fee arrangement and costs and expenses. So my contingency fee is 33% of the gross amount of your recovery. So that's before any other costs associated with the representation. Just as a reminder, contingency is I'm only going to get that 33% if you recover. If you don't recover, and that's outlined in here, then you're not liable for any attorney's fees at all. Also, I advance the costs associated with like court fees and things like that, like filing fees. So that is technically separate from the contingency fee. So that is one thing, like if we don't recover, if you don't recover, um, then there would still be some expenses incurred, but
Okay.
I will keep you informed of all of that, and it's not gonna be nearly as much as what.
Yeah, it's not gonna be
the
like
legal fees will be.
thousands of
No,
dollars, okay.
no. And we can go over that more in more detail as it comes up.
Okay.
But and then this next section just goes over what some of those additional expenses might be. So as I mentioned, filing fees, if we need to do any deposition or get any expert witnesses. I don't really foresee needing travel expenses, but stuff like that. That's what would be in addition to legal fees.
Okay.
Next part is about your recovery. So any settlement or judgment amount gets deposited into, we have a trust account. And I will promptly notify you of the receipt of those funds. And then there's a specific order that we operate. First year, we take out our legal fees. And this is again, if we recover and there's a contingency fee, we take out the costs from that as well as, first it would be the like filing fees and deposition fees, and then the contingency fee is taken out, and then we send. Everything else goes to you.
Okay.
You're able to terminate your representation with me at any time. We just ask that you give written notice. And the only thing about that is, while you don't need cause to terminate our relationship at any time, even if it's like we're really close to, say, if we decided to say go to trial or something, you would still be responsible for any of the costs associated with our work after the fact if you recover. And that's all outlined here. And then it also discusses if I withdraw, these are the only terms under which I would withdraw. I have never had that happen. It's definitely very rare, but it can happen. It has happened with other attorneys, so that information is there. There's a section just saying that we can't guarantee an outcome. I think we talked about that last time. It's, as strong as a claim is, you never really know until you know whether or not you're going to recover. This just discusses confidentiality, which we also went over last time, but just know that all of our conversations and communications are confidential and protected by attorney-client privilege. With those exceptions, like we can't be trying to commit crimes or fraud. This is about dispute resolution. If we try to, or if you have any issue with how we went about your handling your case, we can have that discussion. And that's kind of the gist of it. Also, this last little bit here is just to say that you have 24 hours to rescind. Okay. So if we sign this, we talk, we have this conversation, we move forward, and like tomorrow morning, you're like, wait, I actually don't want to do this. Just write me an email and we're good.
Okay, great.
Does that sound good?
Yeah.
All right, so go ahead. You'll sign there and print there and add the date, and then I will sign. And then we are good to go. Sorry, I know that was really long-winded, but
It's no problem.
it's an important set of information.
Do you know the date?
It is 7th. November 7th. All right, so why don't you go ahead and fill me in on what all has happened since our last conversation, and then I'll go over. Well, first fill me in on what's happened, and then kind of give me an idea of what your goals are and what you're hoping to achieve through this representation, and then we'll talk.
Okay. So we talked about, I could file a claim with somebody or something, but it's probably a good idea to talk to my boss who owns the business. So I went and talked to him and I told him that it was just me and him. He'd come by for something, pick up something in the shop, and I asked to talk to him before he left, and he stepped outside. I asked him if I told him that, listen, there was a lot of overtime I had on the table, and it was a couple $1,000 at least. I sat down and did the math. And, that I really needed it right now. And I don't need it all immediately, but I wanted to get paid. And he said, I'll have to look at it and I'll get back to you. So, okay, that's fair. So he left and finished up my workday. I haven't, been working overtime. And about 2 or 3 days later, the shop boss, Nick, walks in, and I'm in the middle of a job. And he said, listen, there's less orders coming in. We're gonna have to cut your days. And I said, why? We've had plenty of orders up to this point. My table's pretty stacked. There's at least another 2 weeks of work in front of me. He's like, yeah, no, but we just know it's gonna slow down, so we can't keep you on full time. So that's crazy. I've been full time for 2.5 years now, something like that. And business hasn't slowed down. I mean, shit, I started working all that overtime because we had too much work. So I said, all right. I finished my day, went home, thought about it, didn't make any damn sense. And it's been what, 2, 3 weeks since we met. I did that a day or two after we met. I talked to him. Then a day or two later, I think it was 2 days. 2 days later, they cut down my hours. So it's been a couple of weeks now, and they keep telling me, don't come in Thursday, don't come in Friday. Show up occasionally. They're like, oh, listen, you're only working a half day today. And I looked at the order sheet. We got more than enough shit to do. They opened up a job posting. Or I heard them talking about it. I haven't seen anything, but they tend to hire people by word of mouth, not by actually opening up a real listing. So apparently there's feelers out there trying to find somebody else to do more custom work. So I don't know. I just don't see how this isn't Ron being pissed that I asked for my money.
Got it. And so you said that they've been shortening your hours, but they haven't officially been and they opened up that job posting, which is suspicious.
I heard them asking, I heard from someone else in the shop that they've been asking around for somebody to do the kind of work that I don't do.
Okay. And, but they haven't terminated your employment or anything like that?
No, I'm still going in 3 days a week. Some, sometimes my Wednesdays get cut in half, but I mean, working 2.5 days or 3 days a week isn't enough.
Yeah. How many hours on average do you think you're getting now? Because obviously before you were working regularly over 40 hours, but now where do you think you're?
Well, I'm doing, not counting lunch because that's not paid. I'm doing 8 hours a day, 2 days. So, another 5 probably on Wednesdays most weeks.
Okay.
So I call it what, 16, 21, 22 hours?
Yeah. So effectively cut it in half.
Yeah, about.
If not more.
Yeah.
Okay. Okay. Well, I'm really sorry that happened. I know that you were really worried about that, any potential.
I mean, I put a little bit of savings away when they started to raise my pay, but it's not a huge cushion. So, I mean, that's why I'm talking to you. If I thought it would change in a month or two, I would just wait it out, but.
Okay. Well, with those additional facts now, and I'm just gonna kind of go back over what I understand from our last conversation. You have been working with this particular garage and this employers for 2.5 years. And what was it, last June, you'd stopped getting, or you were working overtime, started working overtime, but haven't actually been getting compensated at all for any of your overtime. So that in and of itself is a claim right there. Which there are different things that we can do to hopefully remedy that. But now we had discussed you actually going and speaking with your boss first, potentially before, or with, payroll, or whatever, just to ensure that there weren't any maybe admin issues, or maybe they could just get it all situated without having to get the law involved. But now your hours have been reduced, which does appear, at least facially, like it's a retaliation claim. So at this point, we kind of have a few different options. Starting with the overtime. And this is, obviously this is all going to be up to you. And also just at any time, if you have a specific question or something, like, just let me know. But for the overtime claim specifically, as I mentioned last time, there's two courses of options. I won't say that there's a best, I guess. But I'll give you kind of the pros and cons. So for the overtime claim, we can file a claim with the Oregon Bureau of Labor and Industries. And they basically, are you at all familiar with the EEOC, or does it ring a bell at all? Okay. They're like a federal employment law investigation group.
Okay.
And they're like a group of people who basically come up with new employment laws and they enforce them for like federal laws.
Is it like regulation or is it
Yeah.
like law?
Yeah, it's regulation.
Okay.
So the Department of Labor is also kind of involved there, but anyhow, so the Bureau of Labor and Industries kind of functions in that way, in the sense that like the EEOC will investigate claims that employees will file against their employers that violate federal regulations. BOLI will investigate state claims. So the wage or overtime claim, that's a state claim. So we would file that with BOLI. At this point, I mean, your last, I can't recall off the top of my head, I'll have to go back, but it sounded like there definitely wasn't a statute of limitations issue, meaning that we're not like crunched for time.
You said it's something like 2 years?
Yes.
Yeah. The overtime started about 1.5 years ago, so.
Exactly. And your most recent check where you weren't getting overtime was like in the last month.
Oh, yeah, I mean, they cut last month. It would have been checked for last month.
Yeah, before they started reducing your hours, basically, which is the other thing that I find helpful for your case is you were consistently working not just 40 hours, but you were working overtime, and they didn't. I guess I should ask, did they have a conversation with you where they were like, what did they say again before they started cutting your hours? Like, were they like, oh,
what
we're
they've said,
out of money, or what did they say?
They said that orders were short, which is just not true. I mean, I'm not supposed to have access to the full order book, but people leave documents out and about, and I look around. And the order sheets.
Yeah.
I mean, it's shit. It's 4 or 5 months worth of work. If it's not me doing it, if it's a new guy doing it, they're gonna be behind like nobody's business.
Yeah.
It's not a lack of work. It's not that my work hasn't been consistent. I've been providing the same kind of output in general. I mean, what I do is different job to job, but I'm not dragging ass. I'm not taking too much time. These things, I mean, I know what I get paid and I know what these sell for. And they're not the same thing.
Yeah.
There's margin there for sure. I'm not costing them money unless, I don't know, they're buying me something that's secret.
Well, I would hope if they would, yeah.
Yeah, so I can't look at it as anything other than I told the guy who owns the business that I wanted to get paid for the time I worked, which he said I think I have a right to. And then my hours get cut whenever I know there's work. They can say, oh, we're pivoting our business or some shit, but there's orders on the table, and I don't know if that's a contract thing or how the fuck they do it. I don't sell the orders, but people have paid for it, and the work's got to get done one way or another.
Yeah. Okay. That's good to know. So Okay, so sorry, I got a little bit ahead of myself, but so we have that option for the overtime claim to file with
The
both,
state, yeah.
with the state,
Okay.
yeah. And so when we do that, it's kind of then out of our hands for a bit. The Bureau of Labor and Industries does their own investigation and we provide documentation as needed and vice versa.
Mhm.
They would reach out to the employer and collect documentation from there. Basically determine whether there's a claim at all, how much recovery you're entitled to. So in that sense, it's a little bit more straightforward.
Mhm. But that's just for the overtime.
That's just for overtime. Alternatively, if you wanted to, we could just do like a more traditional kind of like litigation route where we file an actual lawsuit with the court
Mhm.
and a state court and basically just like sue your employer and say for all of the money that you were uh not receiving while you were working. And then, attorney's fees and such like and stuff like that, that would all kind of get worked out. For this kind of claim, it's really up to you. I will say that, I mean, maybe you know this from talking around to people, who knows, but anytime that you're gonna go to court, it can be a kind of exhausting process
Mhm.
because you're sort of just at the whim of the court system and also at your employer, and their attorney, if they did decide to then lawyer up. It can be a lot of back and forth,
Mhm.
an uncertain kind of timeline, and also, we just, I mean, again, I think that we'd have a claim, but I'm not 100% sure. Whereas the bully option, and it would just be more work on your end. Whereas the bully option is, like I said, it's just more straightforward. So, and they've got a great investigation team. They're very thorough. So that is probably the one that, if just as your attorney, I would personally probably recommend that one. But what are you thinking right now?
I mean, do you think that I've got equal or better odds of success with the state organization?
I actually don't really think, I mean, your case is so, as a lot, I guess what I should say is, and we can get more into this in a second, but I will need to obviously get, or the state agency would need to get and collect all of your pay stubs, your time sheets and that sort of thing. That is ultimately like, they need evidence.
Mhm.
Courts need evidence, and the state agencies need evidence. So, as long as that's there to support everything that you're telling me, it sounds like you have a really strong claim for the overtime, for sure.
All I
So,
know I have is my pay stubs.
Yeah.
I turn my timesheets in.
Mhm.
I mean, I assume they keep them, but
Well, and that would be another issue too, but you wouldn't need to be the one, and I should also clarify that, you wouldn't need to collect that information if it's not easily accessible to you. We could just, or the state agency in this case would reach out and say, you need to give us this employee's
Mhm.
timesheet information. So that wouldn't be on you. The pay stubs might be easier to get from you, but everything else that we need, we can figure out how to get that information.
Mhm.
So yeah, from my perspective, and from what I have heard from other attorneys that do this work, it's for a claim like yours, where it's a pretty straightforward, like, you should have been getting paid.
Mhm.
I think going that bully route with the state agency is just going to be easier for everyone involved. And also, I just think, since you are still working with them,
Mhm.
it's obviously not, it's still, I'm sure they're gonna be like, oh, dang, this agency is getting, like, you got the agency involved, but it's a little, I don't know. I feel like people
It's
see
different
lawsuit
than a
and they're like,
lawsuit.
yeah, you know what I mean?
Well, he'll definitely lawyer up, that's for sure.
Yeah. But it's up to you. It's
No,
up to you.
I think filing with the state agency makes sense. I mean, honestly, at this point, I didn't want to lose my job, but if they're gonna cut my hours and be a dickhead despite the fact I worked overtime for free, if I can find work somewhere
Yeah.
else. I get, if this comes through, then I'll definitely have enough cushion
Mhm.
I've got a good reputation in town. I can find it.
Yeah, and there are, we can also try to see if there's, or the agency might be able to get some additional recovery as well, just for the time and emotional burden. So the other thing though about this, since this overtime claim is so intertwined with the retaliation claim, I do want to just kind of go over retaliation claims in a little bit more depth for you. Pretty much the way that the law is set up is there are 3 elements that you have to meet in order to establish that, and retaliation is basically you did something that you were allowed to do that was perfectly within your right, and your employer is like, they do something that is pretty
They
clearly.
retaliate.
Yeah, they retaliate, exactly. In legal terms, it would be an adverse action that the employer did, and you were engaged in a protected activity. And basically, that adverse action was caused by you engaging in protected activity. So those are the 3 elements: protected activity, adverse action, and then causation. And it's interestingly, in a lot of other cases, causation can be really tough to prove, but in a retaliation case, it's actually not too difficult. It's pretty clear. Like if we were to gather all of this evidence, right, like of the story that you just told me, of like, for 2 years, you're working 40 plus hours. There's tons of work. We look at the records, like their sales records, and it's very clear that they have a lot of work. But all of a sudden, without your asking or prompting, they're saying that they aren't getting enough, their orders, or their short orders, and they don't have enough hours to give you anymore. And also they've put up a job posting, like that sort of thing, like all of that together. Causation piece feels a little, I mean, again, I don't want to guarantee it, but that feels pretty secure as long as we can collect all of that evidence. The adverse action is that they reduce your hours, which you
I cut my
know.
hours, yeah.
Yeah, exactly. The part about retaliation that can be harder is actually the protected activity piece. Just because usually it's defined by some kind of statute. You did something that under like actual law or under a regulation or something is you were allowed to do. I think right now it's great that we're going to go ahead and file this bully claim, because as of right now, I could do a little bit further research. I'm not 100% sure. Obviously, it feels like you talk to your employer and all of a sudden this is happening. That's wrong. And so it very well might be that in Oregon, that's enough to prove the retaliation claim. But for sure, if you file a claim with bully and they're still reducing your hours, or say we filed this claim and they do terminate you, that's retaliation, potentially also a wrongful termination claim, which we can also look into if that were to come into the picture. But my point is, I think we have a pretty good chance. We have a pretty strong claim here, especially once we file that bully claim for your overtime pay. Oh, sorry, go ahead.
I imagine Ron's a vindictive dickhead.
I'm really sorry.
I imagine, I mean, you know, I work for the man. I do imagine that I'm the only person who works enough overtime to make us think about it. If a state agency comes in, I don't know if, unless he's got a more persuasive lawyer than his ex-wife, then I don't imagine that he's gonna not fire me.
Okay.
Just because he's that kind of guy.
Okay.
So if they do fire me and this wrongful termination thing happens, what is that? You know, I mean, it's not like that's hours I didn't get paid for. Like what do I recover?
Yeah, so in that case, you would recover back pay. And in addition to, honestly, at this point, once retaliation comes into the picture, my understanding is that you can collect not just for like the money that you would have gotten for all the time that we're trying to figure all this out. So if you were to be normally working 40 hours, you'd recover that money. But also you would be able to collect, potentially punitive damages, and like I said, emotional, or, oh my gosh, the exact term is escaping my mind right now. But you would be able to collect more,
Okay,
basically,
yeah.
in addition to not just the money that the income
Not
that you'll
just the
be losing.
overtime.
And the overtime, of course, there would be no question that you would get that, but for the retaliation claim specifically, it would be the money that you've lost, the income that you've lost because you were terminated. And that's just determined by the court. They look at the evidence and they decide exactly.
So like, I don't know, hypothetically, I know it's gotta vary, right? But,
Mhm.
you know, oh, I should have found another, like, if I had quit or if I'd been fired, I would have had notice.
Mhm.
And 2 weeks, 2 months, something like that worth of pay that I should have had notice for or something like that.
Yeah, that definitely would be part of it. And also not just for notice, but like if it takes a really long time for you to find work for some reason. Obviously we hope that that's not the case, but if it does, then the court could very well be like, yeah, he needs to get paid for all that time that it took him to find new work. So obviously it's a terrible situation to be in, and no one wants to be in a situation where they're looking for work at all, but especially under these circumstances. However, because it is under these circumstances, and because you do, from my point of view, obviously, again, I don't have all the evidence in front of me, so I don't know for sure, but from what you've told me and from our conversations, it sounds like you have a pretty strong case, both for the overtime claim and this retaliation claim. The upside is that you would get compensated, well,
Okay.
for, you would get that money back. And,
Okay.
and then some, like I said, so it would be, I guess, what would be considered compensatory damages, compensation you would have otherwise gotten, and then emotional damages.
Okay.
Yeah. And the same thing for a wrongful termination claim, if we can also do that.
Mhm.
And again, I don't
Yeah,
want to get in the
hasn't
weeds of that
happened
yet. Yeah,
Yeah.
exactly. Just because
Yeah.
this is already so much, and I
Yeah.
just don't want to, yeah, I don't want to confuse you or give you more to think about, but just know that he can basically keep digging
Yeah,
his
I think he can
own
do his own
little
grave.
grave. Yeah.
Yeah.
The one thing though that I do need you to just keep in mind, and it's not something that I'm necessarily worried about for you specifically, but just in general with retaliation claims
Mhm.
and in situations where it's just, if you're working for an employer and they're starting to treat you poorly, it can be really taxing
Mhm.
mentally, especially if they're not actually terminating you. So say you don't get terminated, but they keep cutting your hours, or maybe they start,
Put me on worse jobs.
yeah, or saying like
Send
being
me
really
out
mean to
for-
you, or yeah, just anything like that. That can be really taxing, and it
Mhm.
may get to a point where you resign.
Mhm.
That is something I wouldn't recommend, at
Okay.
least not while we're in the process of doing this,
Mhm.
because then it gets tricky. Especially for like a wrongful termination claim, like that pretty much goes
Yeah.
out the
Then,
window.
and who would you have actually fired me if I didn't?
Right, we have to show that it's a much harder, tougher burden to prove, because yeah, we would have to show that you were basically forced to resign, and that's.
I've had plenty of bad jobs. I
Yeah.
don't imagine they're gonna be able to make this one bad enough to make me quit.
Yeah, I'm sorry, I do feel it stinks, because like
It is what it is, bosses.
litigation, lawsuit, or just any of this is tough as it is, but especially when you have to be around them as often as you have to be around them, so.
I mean, at the very least, the guys I work with are good guys. They're not gonna be dicks because I ask for overtime.
Okay.
They're,
Well, I'm glad that you have them at the very least, but also, oh, and the other thing I wanted to mention, just in connection with what we just talked about, is like if you were to say if you were wanting to start, because you are only getting paid overtime, or you're only working part-time. Maybe you want to look for additional part-time work, or like gig work, or just like, doing little side jobs, odd jobs here and there. That's fine, but I just would maybe wait. Like I said, even if you get another job, resigning can just from this one
I
can
mean,
create some issues.
I got some side hustles putting out,
Okay.
you know, just odd fixes for friends and stuff like that, and I can.
Yeah,
You know, I got some buddies who need some drywall work done, stuff like that.
Okay.
So it's not a problem if I go and do that though, right?
no, not at all. You can totally continue, or you can totally do that. I would say like you're within your right, especially because like at this point, it's all just kind of talk. We haven't actually filed anything yet. You haven't actually received any recovery yet. So I would say, yeah, if that's in your bandwidth, physically and emotionally to
Rent-
do that.
Rent's gotta be
then-
paid one way or another.
Yeah, exactly. So, and at the very least, you don't owe me anything, like I said, at any point until we get to the end of this. But hopefully by that point, you'll have a pretty nice recovery. So my recommendation at this point is we go ahead and file that bully claim ASAP.
Okay.
So.
Do I need to do that or?
I will fill it out and file it, but I will be in communication with you this week to get any information that I don't have from our conversations already. I might reach out to you and just make sure that I've got everything correct, and then I'll file it for you. So you don't need to do that. All I need from you at this point is just check your email.
Okay.
Or be near your phone. I might shoot you a text or whatever you prefer. And then once we get that filed, at that point, we're invoking your statutory rights. And then as you just keep record of anything that happens at work. And then I'll start building up the retaliation claim. And I guess I didn't mention it, but for the retaliation claim, it's a similar situation sort of as the overtime claim. We can file with the actual EEOC, so that federal body, or we can bring a lawsuit. That part, I think we collect some evidence first, get some records, and then we kind of make a decision from there. So I'm thinking at this point, we'll file that bully claim and then we'll set up a time to meet after that. And maybe like within a couple of weeks, if not sooner, I would say we'll maybe plan to meet in a couple of weeks, but, and we'll have to meet periodically just by virtue of filing claims and going through this process, but obviously if something happens, like you're terminated, then just let me know immediately. And then we'll meet sooner. But yeah, those are my thoughts as of right now. But what do you have? What are you thinking you want to do? What feels sticky for you, if anything? Like, do you have questions?
I mean, at this point, like I've started asking around, I want to know what's open. If they're going to keep cutting my hours, obviously, so fuck it, fuck them.
Okay.
Yeah, I mean, 2 years of hard work and unpaid overtime, fuck them.
Yeah.
So if we got to take them to court,
yeah,
I mean, if I don't have to worry too much about too much out of pocket, and if nothing happens, then I can roll those dice.
All right. Well, like I said earlier, I am really sorry that this is happening. It does sound like, if they're not gonna seriously entertain a conversation about getting you the money that you've lawfully earned, I would say it may be time to start thinking about new employment. Unfortunately, I wish more people understood that the law exists for a reason. They're not above it. I'm just going to go over my notes really quick here just to make sure that there's nothing else that I'm forgetting. And the other possibility too with all of this is, they may get the bully complaint, your employer may get the complaint and just want to settle. And then it'll be real easy from there, but we don't know at this point.
If all that wraps up and we don't take them to court or they settle or whatever, and all that's done, I can quit then, right? After,
once the retaliation claim is figured out,
Yeah.
the overtime claim, that could get situated first. And then I would, if you're
But
still
yeah,
working with them.
let's say all of it gets done, you
Mhm.
know, let's say they settle for the
Mhm.
retaliation or whatever. That's all done. It wouldn't come back to bite me if after that I said, okay, fuck this job, take it and shove it,
Yeah,
and then,
yeah, you
Okay.
can definitely leave at that point.
okay,
That's, yeah, that's pretty to be expected, with an employee, especially a lot of employment cases, once you're suing your employer, most people, it's so interesting, like. Sometimes courts will say, okay, no, you have to hire them back. But that doesn't happen a whole lot because it's also like, do you really want to go back there after
Yeah.
all this? Like,
Yeah.
some people do. And if you did want to do that, we could talk about that, but. Which I guess,
Yeah.
is that something that you
No, that's not something
would
I
want to
want.
do? I don't want to
I
make
don't-
it seem like
no,
it's
it's
you
not-
have your reasons.
It's not the worst group and it's, you know, it pays well, but, it ain't, you know, it's gonna hang over me the whole time I'm there, and I still have a decent reputation everywhere else.
Yeah.
You know, so I think I should be able to find work somewhere else and about the same, and you know, I worked there 6 months, I get my pay back up to where it is now.
Well, I can also, as we're going through this, I'm obviously right now you're still working there. And it sounds like you have some side hustles, which is great, lined up potentially. But as we're going through this, if there is a termination, we have that claim, I can get you connected to some employment resources as well. Since that is something that comes up for a lot of our clients. But no, I think at this point, we're all situated for right now.
Okay.
I will, okay,
I-
go ahead.
Can I just, I'm sure you're gonna need pay stubs. I think I still have all of them for about at least the last year.
Yeah, okay.
I'll have to look for the other ones. Is it okay if I just take a photo and send them to you for now? I don't have a photocopier at home or anything.
Oh, yeah, for right now, that's totally fine. Photos are great. I might maybe for our next meeting ask that you bring those in.
Okay.
So we can then scan them and then I can give them back to you. I'm not gonna hold them
Okay.
hostage.
I got them, I assume for shit like this. I just knew you hold on to them.
Oh, yeah, well,
So
and
I
at least you did
Put
that.
them in a box.
Yeah, no, that's great. Photos would be great. Like I said, I'll reach out to you. It's what today's, oh my God, today's Thursday. Wow. In my head, I was like, it's Tuesday. We've got the rest of the week. My goal is going to be by, let's say, by next Tuesday to have the claim filed. Does that feel reasonable? If
Yeah,
I need to
it
reach
would.
out to you between now and then just to get
Yeah, I think,
information?
yeah,
Okay.
Saturday I might not be in phone service, but.
Totally fine. It's your weekend. I'm hoping to also not be in service on Saturday, if not needed. So great. So then, yeah, I will plan to try to have this filed with Foley, the overtime claim. Specifically filed with Foley by Tuesday. If for whatever reason that's seeming unrealistic all of a sudden, I will keep you informed, just like I mentioned in that agreement. And then once it is filed, I will also make sure that they might reach out to you as well to ask questions, so just be aware of that, and get a statement from you.
Call me or something.
Yeah, exactly. And then after that, I guess some other homework, I guess, for you is just, and I know I kind of alluded to this earlier, but try to keep a really good record, even if it's just like you type something into your notes app on your phone of interactions, or like take photos of your timesheets or your schedule. I don't know if they like send you a schedule a week in advance or something like that. Just keep track of.
I rock up Monday and they tell me what I'm doing that week.
Okay, I got you. So just jot that down somewhere.
Okay.
I don't know if you guys ever just be a little bit more.
Collect
conscious of
information and
any information, texts.
If I have
phone
like a
calls.
conversation or something, I'll probably just type it up and email it to you and just say this happened.
Yeah, that's perfect.
It's just that way you know about it, and
Mhm.
that way I actually write it down. Otherwise, I will totally forget.
Yeah, that's perfect. Because that is what's gonna start ramping up that retaliation claim. So that is all I'm foreseeing in the near future. Like I said, I don't want to get too far ahead just yet. Baby steps. And then I'll reach out to you, after this to schedule our next meeting. What is your availability generally looking like? Are Thursdays pretty good for you these
Yeah,
days? It sounds like they're pretty
as it
open.
stands, Thursdays and Fridays are
Okay,
consistently open.
okay, that is
You know,
unfortunate.
if it changes, I'll let you know. I'm sure that'll be
yeah.
relevant for a few reasons.
Oh, God. Well, yeah, I think that's about it. And then our meetings in the future will be pretty similar.
Mhm.
I'll probably ask like for updates, and I will update you, of
Mhm.
course, on like any claims that we have going. But yeah, that's about where we stand. Any other questions?
I don't think so. I think it makes sense.
How's your mom?
She's all right. I mean,
Is she glad that you are doing this? All right. Well, if you don't have any other questions for right now, I will go ahead and let you go. Be free, enjoy. We finally have some nice weather
yeah,
after days and days and days of very cold rain. So yeah, enjoy the rest of your day to the extent that you can. If you do think of any questions though, just like I said last time, you know where to reach me. I'm very happy to respond to emails, but also I know texts as well. Whatever works.
okay, great. Thank you.
Awesome. Yeah, you're welcome. And this, you can hold on to this as your agreement.
Okay, thank you.
Yeah.
Yeah, see you, what did we say, next Thursday first?
A couple weeks from now,
Couple weeks
2 weeks
from
from now, is probably when we'll set up. our
Can you
next
email me
meeting.
a reminder?
Yes,
Okay,
yeah,
thank
I
you.
will shoot you an email. I just want to make sure I double check my calendar before we
Mhm.
set anything.
Okay, yeah,
For
no,
Thursday,
that
but
makes sense, yeah, all right.
All right.
Well, have a
Thank
good one.
you. You too.